professionally. That's what our rules say. So when her counsel puts evidence of vote padding and gets confirmation from a witness of that evidence, my lord, this is a serious matter because it affects the whole issue of the rights of voters to have a credible election with results that are declared in accordance with valid votes and all that. And yet we had that situation where counsel put to the witness. And counsel did not only put to the witness those allegations of vote padding. Counsel put to the witness also allegations that for one regional coalition in Eastern region, there were 2 coalition sheets. And counsel sought to go into that, which I will not go into. But my point, respectfully, is that counsel, in fact, in doing all that, counsel is really the one who has shown clearly the importance of the testimony of the chairperson to address these issues. My lords, we also had the testimony which showed, again in response to a question from the bench, which showed that the form which ostensibly, the Form 13 so-called, which ostensibly the chairperson had acted on prior to her declaration, was not in fact the form that is provided for in regulation in CI 127. That testimony was before this court. And my lords, it is respectfully only fair for the chairperson to have the opportunity to admit or deny that important piece of evidence which came from PW2 in answering a question from the bench. It is therefore our respectful submission that none of the points made in the affidavits in opposition provide a justification for our not being allowed to reopen our case, and therefore that your lordships, in the interest of achieving substantial justice, as your lordships have often expressed, you allow us to reopen our case on the grounds that we have urged and for the limited purpose that we have urged before you.
Yes, Mr. Minuvo.
My lords, we are opposed to this application to reopen the case of the petitioner. Lords, we have filed an affidavit in opposition. And Lords, we rely on the depositions in the affidavit in opposition. My lords, this application has been filed following the ruling of this court on the 11th of February 2021. Lords, I believe that, therefore, Kanda demands that the petitioner would, in deposing to the reasons, assign the appropriate reasons to the court. Lord, may I kindly refer you to paragraph 11 of the affidavit in support. In that paragraph 11, it is being alleged that the reason which the court gave was basically that, let me just read it. In respect specifically of the witness statement filed on behalf of the first respondent, the court decided that since she had not been called as a witness by the first respondent for her witness statement to be admitted in evidence, she would give under oath she was not available to be cross-examined. Lords, I have read the ruling of the court. Nowhere did the court say what the petitioner has said in paragraph 11 of his affidavit in support. Indeed, my lords, what the court said was that, with your kind permission, simply put, we are not convinced and will not yield to the invitation being extended to us by counsel for the petitioner to order the respondents to enter the witness box to be cross-examined. So the reason the court gave is there that the petitioner is attributing another...
Mr. Menuvo,
yes, ma'am.
You cannot cross-examine a person who has not testified in chief.
Pardon me?
A person who has not testified in chief cannot be cross-examined.
Yes.
But this person had not even testified in chief.
Yes, your ladyship, but the point I'm making is that a reason is being assigned by the petitioner
I appreciate the point I'm making. What I'm saying is that it seems to me to be a strange argument, because you cannot even talk about cross-examination when there hasn't been an examination in chief.
Your ladyship, where a supplicant, an applicant before the court, makes false statements to support his application, I believe that it is only fair that counsel will point out those false statements to the court. That is my submission, that the court assigned reasons in its ruling of 11th of February, and it shouldn't be what he has said in his affidavit in support.
My lords, I do not think that it can be claimed that we made a false statement. My lord, there is an account given of your ruling. Counsel is entitled to give a different account. Ultimately, it is for your lordship to determine whether what we have said. But to say it's a false statement that we have made in the affidavit, that, my lords, is not acceptable.
Well, I will draw the word false. It is an incorrect statement. My lords,
it's a deposition. It's a deposition on oath.
Yes, my lord. My learned friend was saying that my choice of word false, and that is why I said it is an incorrect deposition. Deposition, I get the correction, my lords. My lords,
or it doesn't reflect what?
Yes, my lord. Yes, lords. A perusal of paragraph 13 and 14 again creates the impression that the court ruled in those matters that's in the review, in the interrogatories, on the basis that the first respondent chairperson will be available to be cross-examined. Lord, again, with your kind permission, regarding the ruling of the 11th, this is what my lordship said when that argument was made. We are also of the opinion that the filing of affidavits in interrogatory applications with the position that the deponent will be available for cross-examination does not make the deponent compellable to adduce evidence at the trial. As already stated, learned counsel for the petitioner only referred us to an affidavit deposed to by the chairperson of the first respondent in opposition to an interrogatory application to serve interrogatories. That affidavit is not evidence in this petition to enable us compel the first respondent to mount the witness box. So again, my lords, on the 11th of February, the court was very clear in its ruling. Now, my lords, in paragraph 16, the petitioner deposes that representations were made by me, or for that matter, the first respondent's chairpersons, to him. Lords, I think that that is a very unfortunate statement, simply because the petitioner decided on his own to take the steps that he has taken in this matter. The petitioner, first of all, did not obey earlier orders of the court. And then when he obeyed the orders, he filed 2 witness statements. And then the petitioner subsequently sought leave of the court to call a witness. Then the petitioner decided that in spite of the fact that I had intimated in my petition that I was going to call 5 witnesses, I am limiting myself to 3. I close my case. How petitioner will now see to say that it is as a result of misrepresentations that were made to him that he closed his case, I cannot fathom.
My lords, respectfully, I never said misrepresentations made to me. I never said misrepresentations.
Yes, Lord. Lords, he said representations. I corrected to representations. Lord, again, paragraph 20 of the affidavit in support refers to a matter that this court ruled upon on the 11th of February 2021. This is what the court said on that. That is so, my lord. Paragraph 20, where
constitutional rule, the first respondent, please.
Yes.
Are you not talking to via paragraph 20?
Yes, sir, my lord. Yeah, paragraph 20. Yes, my lord.
Constitutional rule.
Yes, my lord. And my lords ruled on it, made a pronunciation on it. That was just
you see, this application is not for review of the decision. Technically, in all substance, it is not for review. The case has been closed by both parties, and they are seeking the leave of the court to reopen. If I understand what the motion stands for.
Yes, my lord.
Yes, so please address it. This is paragraph 20 is just the constitutional rule.
Very well,
the first respondent
my lord.
is deemed by law to play.
Yes.
You can well, it's your case, but I think it is just there to maybe place emphasis on it.
Well, my lord, with respect, I move on. May I refer your lordship to...
Mr. Manuvo?
Yes, my lord.
I think what my lord, the Chief Justice, is saying is address us on why the petitioner should not be allowed, should not be granted leave to reopen his case. That is what you want to hear from you.
Yes, my lords, I will come to that. But for example,
you are taking too long to get to that. That's what interests us.
Well, so my lords, I take it that the paragraph 25, which is an untruth about what happened regarding pen drives. I think that in fairness...
you see, just like I drew Mr. Chikate's attention to, we only function with law here. So, first, my Lord Mafusa asked him what rule he was coming under. Then I asked him the grounds on which he wanted us to exercise our discretion. These are the things that we are interested in. So when you oppose it, tell us why we cannot grant this application or should not grant this application. And then the cosmetics can be dealt with later.
Well, my lords.
You see, you have spent some time seeking to attack the depositions in the affidavit in support of this application. Yes.
Well, my lord, I would move on. Lord, it is my submission that this application is not warranted by any rule of law or by procedure. And my lords, this court is primarily not a trial court, and therefore we may borrow from Rule 5 of CI 16. And Lord, if we borrow from Rule 5 of CI 16, the closest, yes, my Lord, Rule 5 of CI 16, which permits the court to go and look elsewhere. Lord, the closest that, yes, my Lord.
Is it not a settled practice that a case can be reopened in appropriate circumstances?
My lords, it is a settled practice, but there are circumstances.
Yes.
And so, my lords,
go there. That is what we want to know. They have argued at length that they want to reopen the case, and it is permissible in law. So you satisfy us in opposition why the application ought to be refused, because this application technically is directed against you.
Yes, my lord. My lord, with respect.
They also close their case. They have. I'm talking of the second respondent. They also have a role to play, but they are not suggesting in the list that if the case is reopened, they are going to serve the second respondent to come from the Jubilee House to give evidence.
Yes,
have they said so?
My lords. Well, I take a cue. My lords, the view I hold is that if I appear before the Supreme Court,
it is the court which is inviting you to address us on some material which is agitating our mind.
Yes, my lord.
Yes.
My lord, so I will plead with your lordships to refer to a high court decision, which I know is not binding on your lordships, but with the greatest respect, it will help throw light on the circumstances under which a court will permit a party to reopen a case. My lords, may I refer your lordships to the case of Anobil versus Obosu and another, 1982-83, Ghana Law Report. Anobil versus Obosu, OBOSU and another, 1982-83, Ghana Law Report 585. Lord, in that case, there was an application before Osefri J, as it then was. Lord, this was to reopen a case after the parties have closed their case. Now, His Lordship, in deciding whether or not to grant the application or refuse it, relied on the case of Young versus Kershaw. Young and then versus Kershaw. Kershaw, Kershaw. And Burton versus Kershaw, consolidated. $18.99. 81 LT NS 531 at page 532. It's a Court of Appeal of the English courts which Osefri relied on. With your kind permission, my lords, I read. It is a matter of greatest importance and has always been so treated by the courts that all material evidence which could, with reasonable skill and diligence, be produced at the trial shall be the only evidence which can be considered and must be adduced at the trial. It is obviously in the public interest that parties who have gone through the ordeal of litigation and have had their rights settled at the trial should not afterwards be allowed to patch up the weak parts and fill up the omissions in their case by means of fresh evidence. It is true that in special and exceptional circumstances, a new trial has been granted because new evidence has been discovered. But the rule which permits that to be done is fenced round with many limitations. The party asking for the new trial must show that there was no remission on his part in adducing all possible evidence at the trial. Then again, as to the class of new evidence, the rule is that the new evidence must be such that if adduced, it will be practically conclusive. That is, evidence of such a class as to render it probable, almost beyond doubt, that the verdict will not be different. And so, my lords, it's my submission that just as in Young versus Kershaw, this petitioner, with very competent legal representation, elected of his own volition to close his case, this should not afterwards be allowed. He should not afterwards be allowed to patch up the weak parts and fill up the omissions in his case by means of fresh evidence. And the only reason is that I wish to call the chairperson of the first respondent, who is the adversary, into the box by way of subpoena. My lords, this whole process that has been filed is an abuse of the court's processes, my lords. Lords, with greatest respect, I have gone and done a bit of research all the way back to 1876, when we received the common law in our jurisdiction. I have not come across one case where a party closes his case and then he is seeking leave to reopen the case only because he wants the adversary to enter the witness box for him. Lords, it totally will collapse our adversarial system. Lords, we ask ourselves the question, assuming that this application is granted, does that mean that the court will now open the floodgates for the first and second respondents to give rebuttal evidence? Lords, it is just going to abuse the process, and it does not augur well for the determination of this matter, a specific matter under Article 64(1) of the Constitution and CI 99. Lord, for example, the motion is titled an application to enable, if I got it right.
No, it says motion of notice for release.
Yes, my Lord.
It's a court of record.
Yes, I'm coming to read it. It says motion on notice for leave to recall the case of the petitioner to enable reopen the case of the petitioner to enable the chairperson. My Lord, the key word is enable the chairperson of the Electoral Commission to testify. My Lord, this alone, the title alone of the motion, should be a ground for a refusal of this application on grounds of abuse. My Lord, well, the body says something else. He says that upon serving a subpoena. Lord, I believe that if I refer your Lordship to Order 39, Rule 5 of the High Court Civil Procedure Rules, CI 47, the rules attach pain of punishment, among others, where a subpoena is served and you don't take certain steps. So, my lords, I believe that the depositions in the affidavit in opposition with reference to a subpoena, it's my submission, were right. Lords, there has been a submission which is to the effect that the way I cross-examined the first witness of the petitioner, I could only have gotten information from the chairperson of the first respondent. But my lords, if you go through the record, I used the witness's own exhibit D and E to make my analysis, and he admitted saying, and Lords, regarding the evidence of the second and third witnesses of the petitioner, Lords, what they said, how they contradicted themselves, is on the record. So the issue of the two different stories are for the court to determine. Very well, my Lord. Lord, I'll be ending soon. My Lord, I wish...
It's your time.
Yes, my Lord.
We are not even allotting time for counsel to be so, limited to within a very short time to present the submissions.
Yes.
So please try and organize yourself and present your case. That is all.
Yes, my Lord. I have addressed you on the abuse of process, and then I just wish to end, my lords, with the fact that a person summoned on a subpoena testifies in court as the witness of the party who caused the subpoena to issue. This application that serves as notice to your lordships that your court will be required to issue a subpoena for the first respondent to testify as a petitioner's witness. Again, my lords, it confuses our adversarial system of adjudicating.
Mr. Chikata said the person will be an adverse witness.
Yes, but your ladyship,
hostile.
Yes, but definitely it is a party that calls a hostile witness.
So, Mr. Manubo, can you address us on section 26 of the Evidence Act?
Yes.
Which was argued by...
Stop it.
Yes. My lords, with respect, section 26 that does not arise at all. Lords, if you go to section 24, you go to section 24, it says that where the basic facts that give rise to a conclusive presumption are found or otherwise established in the action, no evidence contrary to the conclusively presumed fact may be considered before the tribunal of fact. Then it is juxtaposed with section 26. It says that except as otherwise provided by law, including a rule of equity, where a party has by its own statement, act or omission, intentionally, deliberately caused or permitted another person to believe in a thing to be true, etc. Because a combined reading of these two do not support the petitioner's case one whit. My lords, what are the presumed facts in this matter? The presumed facts, so far, the petitioner has been silent on. All he says is that, oh, I didn't anticipate that the first respondent will close his case, and therefore, I think that there are matters that will support my case, and therefore she should be called. That's it. It has nothing to do.
If I heard Mr. Chikata right, the presumed facts are that, one, in your statement of case, you alluded to the fact that the chairperson or the first respondent will make himself available for cross-examination, that he will testify. And then the other one was the averment in the position where she indicated to be available.
That was why I was referring your lordships to the various rulings on the court that had determined the matter. But my lord said I should go to the sub. So it's my submission that the various rulings by the court for interrogatories, review, discovery, they have all addressed the matters that he is raising. That's my submission. Lords, on a lighter note, God is a God of conscience. My Lord, I believe that.
Ask him to go that far. He's in the court of law.
Yes.
Yes.
But my Lord, with respect, with the greatest respect.
When we come here and we take the oath and we swear on the cross or on the Bible, so be it. Yes.
My Lord, with respect, my counsel for the petitioner consistently made statements attacking the faith of the chairperson of the first respondent.
We corrected him. I think we corrected him that we are not here to demonstrate the
very well, my Lord,
of parties and witnesses.
Very well, my Lord. Yes. Yes. Lords, lastly, it is my submission that no representation has been made whatsoever to the petitioner for which, based on that, he is bringing this application. Because I don't think that it is fair for the petitioner to blame the respondents rather than himself for the reason why his action had taken the stages that it took. Because I repeat that the first respondent is vehemently opposed to this application and prays for its dismissal. I'm grateful to the court.
As I said, the application is directed basically against the first respondent. But since you were served.
Yes, my Lord. And I believe that the ruling of the court on the application.
Oh, it will affect the case in general. That is why we want you to. Yes.
Materially our position in this matter. So we are entitled to give a full response to the application. My Lord, I wish to make a preliminary observation, submission, which is that ours is an adversarial system of litigation. It is not inquisitorial. Secondly, in that system of litigation, the question of burden of proof and the burden of producing evidence is fundamental. It's one of substantive law. And therefore, a party that bears the burden of proof and the burden of producing evidence, as the petitioner undoubtedly does, must effectively meet that burden of proof. And Lords, it is well established that where the party bearing the burden of proof and burden of producing evidence fails to meet these two burdens, the court has every right to dismiss the party's plaint, because the party's reliefs can only be obtained if it leads evidence that meets these two burdens. And it's our submission, my lords, that to date, the petitioner, in our respectful view, has failed woefully.
Are you addressing this?
No, my lords.
You are making a general. Don't go there.
My lord, I'm setting a foundation for my specific arguments. You know.
These are general propositions of law.
Yes.
Yes, and credit us with that knowledge of the law.
Very well. My lord, I wish to rely on my depositions, the depositions in the affidavit of second respondent in opposition to the petitioner's motion for leave to reopen the case. All the depositions. And my lords, particularly, I wish to refer your lordships to paragraph 12, paragraph 13, paragraph 14, 15, 16, and 17. My lords, it is our view that the general principle of law is that once a party to a suit announces to the court that he has no additional evidence to adduce and thus closes the case, the court is obliged to affirm that decision of the party. And my lords, we wish in that respect to refer your lordships to Lai versus Oforiwa, 1984-86, 2 Ghana Law Report, 410 at 427. And that is a Court of Appeal case, Oforiwa, 1984-85, 2.
1984-86.
My lord, it's 84-86. 2 Ghana Law Reports, 410. A Court of Appeal case, where at page 427, the court held that the learned counsel submitted that the trial was unsatisfactory, for the learned trial judge closed the case for the defense when the cross-examination of the defendant's witness had not been completed. I think this is not a fair criticism of the learned trial judge, for the record clearly indicated that it was the defense counsel who announced to the court that he was not calling further evidence. He was closing his case. In the circumstances, the court could not do otherwise but to accede to the request of the learned counsel and close the case for the defense. Counsel for the defendant contended that in any case it was wrong on the part of the counsel who appeared in the court below to have closed the case of the defendant at that stage, simply because the witness was not available for further cross-examination. But it seems to me that the learned counsel in the court below acted wisely and in the best interest of his clients, and that any counsel placed in the situation in which counsel found himself would have acted in similar manner. And Lord, it is our submission that it was counsel for petitioner who voluntarily announced to the court that he had closed his case. My lords, he did so taking note of all the evidence adduced by his witnesses and through cross-examination of his witnesses. My lords, that evidence included what happened in the strong room. The evidence also included the alleged conversation between the third witness of the petitioner and the chair of the first respondent, and it also alleged irregularities in the collation of results. My lords, the petitioner led all the evidence that he had in proof of these allegations through the three witnesses. My lord, he cannot, having led evidence that was within his knowledge, or that he could have, by exercising due diligence, obtained, now come back after closing his case to apply to the court to reopen the case, simply to lead further evidence on the same matters. My lords, the petitioner also led evidence on what he considered to be unconstitutional actions, lack of transparency and fairness by the chairperson of the EC. Evidence was led on all these things. My lord, so the question is, if the case is closed and the respondents elect not to adduce further, enter the box and adduce evidence, the question then is for the court to look at the evidence before it and determine whether or not the petitioner has led evidence to meet his claims and reliefs. And my lord, it is important to underline the point that this has absolutely nothing to do with why the first respondent's chair does not want to enter the box. It is a totally irrelevant question at law. It is totally irrelevant. Again, it has nothing to do with the suggestion that the first respondent's chair must be pleased to have an opportunity to vindicate herself. My lord, these matters are completely irrelevant to the application to reopen one's case and lead what in effect is fresh evidence. Because the idea is to reopen the case, subpoena the first respondent's chair, so that he can lead further evidence. That is new evidence. And my lords, it is our respectful view, that the petitioner is bound to meet the time-tested conditions established by this court to lead new, fresh evidence. He cannot hide behind the application to reopen so as to subpoena, to suggest that this is not in substance an application to adduce fresh evidence. And if it is, as I think it is, then he must meet two basic conditions. One, that the fresh evidence that he is seeking to adduce through the subpoena was not available and could not have been obtained through due diligence. My lords, it's a submission that the proceedings of this court show clearly that the evidence on these four matters, what happened in the alleged encounter between the chairperson of the first respondent and the second and third witnesses of the petitioner, what happened in the strong room, the allegations of irregularity are clearly before this court. So it cannot be fresh evidence. Secondly,
it's not asking for fresh evidence. Please look critically at the motion.
He's seeking to reopen the case.
That's right.
So that he can subpoena. My lord, and that is why, my lord, with all due respect, that is why I think that the substance of this, or the content of what he intends to achieve through the subpoena must be assessed, evaluated by this honorable court before it can decide whether or not to exercise its discretion in granting the application to reopen.
I think, Mr. Jesse, we heard him. Sorry, Mr. Kutampa.
my lords, my good friend, Mr. Chachichikata referred to me as my friend Sheshe in the course of these proceedings.
You see, I think he made a point that they want to reopen their case so that they can serve subpoena on the on Mrs. Jane Mensah, so that she can be treated as a hostile witness. Yes. So address that, please.
My lords.
Mr. Kutampa, whilst you're addressing it, I also understood from him that you did some harm in cross-examination. You brought certain things out in cross-examination. So he should be allowed to speak to that through the process of the subpoena.
Yes. My lord, our case is that at the time he was electing to close his case, he knew, the petitioner knew these new matters that were elicited from his witnesses were matters of record. And if he really intended to do that, he should have applied to the court to enable him to lead, to file a new witness statement, to lead evidence on that. He didn't do so. He had all the information at that time, and he boldly declared to the court that he was closing his case. The only reason why now the petitioner is applying to reopen his case is because after he closed his case, the respondents exercised a right that they had not to adduce any evidence. And my lords, counsel for the petitioner and the petitioner cannot say that they did not have an inkling of an idea that this was a possible approach that the respondents would adopt. First, because it is a process that is available in any trial for defendants.
Second, Mr. Akotompa, look at paragraph 16 of the affidavit in support. They said they were taken by surprise.
Yes.
By that year.
Yes,
it therefore came as a surprise,
yes,
that both counsel for the respondent announced on Monday, 8 February 2021, that this was no longer the case. This was no longer the case. Paragraph 16 of the affidavit in support. Which means they had prepared to cross-examine your witnesses. And that was why they closed their case.
Yes.
They had no inkling whatsoever that you were going to close your case.
Yes.
And then this matter came to them as a surprise.
Yes. My lords, if I may respond to that. My first point is that if they had thought through fully the case of the respondents, they would have known that this was very likely to happen. Because right from the beginning of our filing our answers, we had served notice to them and the court. But we didn't think that we had any case at all for us to be even heard. And yet, this honorable court, in its own wisdom, directed that you would deal with our preliminary objection at the end of the trial. So they must have had notice that it was likely, if they failed to lead sufficient evidence, that we will not adduce any evidence. And consistent with our original and primary position, we would ask the court to determine the matter on the evidence before it. So, it is, I cannot believe that my learned friend, Mr. Chachikata, would not have anticipated this matter as a matter of strategy. He should have, and if he didn't, well, my lords, that would be too bad for his client.
Mr. Akotompa, if I recall, your submissions are already on file, aren't they? Your preliminary objections?
Yes.
They're already on record?
Yes.
Everybody's?
Yes, they've been served. Now, my lords, so that deals with the surprise. And my lords, again, it cannot be the case that they were relying on the statement made by chairperson of first respondent that even if the interrogatories fail, they would have an opportunity during cross-examination. My lord, that cannot be, as I've earlier stated, cannot be a commitment to the fact that we shall lead evidence to chief. It is only a legal argument that you may have that opportunity during cross-examination. And that opportunity will arise only if you enter the box to lead evidence in chief. So it can never constitute a fact under section, is it 25, 24 of the Evidence Act, upon which they acted to their detriment, and therefore we are estopped, or the first respondent is estopped from exercising his right not to adduce evidence. It cannot be. And my lord, what is even more interesting is that those provisions of the Evidence Act, my lord will see that section 24 that he reads says that conclusive 24(2) reads, conclusive presumption include but are not limited to those provided in section 25 to 29. And my lords, if one goes to 25(1), it says, except as otherwise provided by law, including a rule of equity, the facts recited in a written document are conclusively presumed. Again, in 26, it said, as otherwise provided.
That's on 24 and 20. 25 deals with the contracts and conveyance. And
yes, my lord, I'm saying that we will see these provisions must be read as a whole. You cannot take this out because section 26 again repeats the except as provided by law, could be real evidence. When a party has by his own statement, act, or omission, intentionally or deliberately, caused or permitted another party to believe a thing to be true, and to act upon such belief, the truth of that thing shall be conclusively presumed. So there are exceptions in law and in equity. So it is not, and the same goes for section 27, 28, and 29. So my lords, I think that it is misconceived for counsel for the petitioner to suggest that the conclusive nature of the alleged statement of fact by first respondent is not limited in any way. And it is, in our view, limited by the right of the respondents to elect not to adduce evidence. My lords, again, we wish to refer your lordships to the case of the president of the Methodist Church of Ghana versus K spelled K-Y-E, K-A-Y-E. Now, the president of the Methodist Church of Ghana versus K. My lord, it's a judgment of the High Court, Cape Coast, by Owusu J, as it then was, delivered on 10th April 1970. It's a one-page ruling, my lord. 10th April 1970.
Is it in the 1970 current cases?
No, it's actually in the law reports 1970, but we couldn't.
1970.
Yes. But we have the current cases. Yes.
Yeah.
Yes.
Okay.
So, my lord,
what did the judge say?
Held. Once a party closes his case, he abandons every right to call further evidence, except with the leave of the court. Precisely, that's why I'm saying that this is an attempt to call further evidence. That is the point I'm making, my lords. You know, and he must be held to the rule or the conditions to be met in order to adduce fresh evidence or further evidence, to use his words. Such an application is only considered when at the time of closing the case, no human ingenuity could foresee the existence of the particular evidence the party is seeking to adduce. That cannot be the case in this situation, my lords. Again, my lords, we also rely on Honorable and Obosu and another, referred to by counsel for first respondents. And again, my lords, refer your lordships to the case of Combat versus Lambin, 19 89. Sorry, my lords. Combat, spelled K-O-M-B-A-T, versus Lambin, L-A-M-B-I-M, 1989, 91 Ghana Law Reports, 324, where Benny J, as he then was, at the close of plaintiff's case, called a witness Somoto, who testified. No, where the trial court.
Was it the Benny J who called?
No, the trial court. The trial court.
I think this was his civil appeal.
Yes. It was a trial court. Yes. After the case of the close of plaintiff's case, the trial court called a witness, Somoto, who testified in support of the defendant. And based on that testimony, the case of the plaintiff was thrown out. The plaintiff appealed against the decision of the court. The High Court, Quorum Benny J. Asidem, was allowing the appeal, stated as follows. The general rule of evidence was that after a prisoner's case was closed, a judge should only call a fresh witness when a new matter had arisen ex improviso, which would not have been foreseen. Such a witness could, in civil cases, only be called with the consent of all the parties. My Lord, let me emphasize, with the consent of all the parties in civil case. My Lords, we believe that the authorities in Canada, a Commonwealth jurisdiction, common law jurisdiction, may, with respect, assist your lordships. And we wish to refer to the case of Ontario Limited versus Sagas Industries, Canada Incorporated. It's a 2001 SCC 59 or 2 SCR 98. That's the Supreme Court of Canada. There, the High Court approved of the two-stage test first articulated in the case of Scott versus Cook, 1970, OJ number 1487. Namely, the test which is intended to assist the trial judge in exercising his or her discretion to reopen the trial requires the moving party, one, to show that the evidence he or she seeks to adduce is such that if it had been presented at trial, would probably have changed the results. And two, prove that such evidence could not have been obtained by reasonable diligence before the trial court. Now, these are the same principles that this honorable court applies in adducing fresh evidence. Now, my lords, it is our submission that this case is about votes and numbers. My lord, there is nothing about the engagement between the second and third witnesses of the petitioner, alleged engagement with the chairperson of first respondent. Even if true, that has been shown to have had any material effect on the outcome of the elections. And we demonstrated that quite thoroughly during our cross-examination of Mr. Asiedin Ketia, where we took him through all the different stages to show that no matter what you do, first, second respondent cross the 50+ threshold, and petitioner persistently remained around 47%. So, and truth be told, the third witness actually declared during cross-examination why they were going to see the petitioner. What was it? They were going to tell him about the irregularities and errors in the collation process. And the question is, does their claim of irregularities and errors in the collation process legally stop the EC and the returning officer of the presidential election from exercising her independent function and duty to declare election results if, in her view, the election results were accurate? The only thing that the petitioner could do would be to come to court to demonstrate that the election results were not accurate. So, my lords, one cannot fault the EC chair until you come to court and are able to show that the election results were not accurate. And
please address us on the general principles which you've based your submission on the authorities.
Yes.
The EC on record is not your client.
My lords, I'm a bit taken aback.
As I said, reopening the case may have serious consequences on the case, because both of you may do so many things. But for the time being, yes, the application is for the reopening of the case for the petitioner. Yes, and your attention has been so much on the first respondent. And I'm saying that on record, they are not even saying that when the case is reopened, they will subpoena the second respondent to mount the witness box.
That's exactly what they said.
So we want you to address us on why the reopening should.
Very well.
Yes, I think you have to understand the bench.
Very well.
Yes, because they are not asking for anything from the second respondent.
Very well. My lords, my simple submission is that to reopen, they must satisfy the two preconditions. One, that the evidence they intend to lead was not available to them at the time they closed their case and could not have been obtained by the exercise of due diligence. Yes. And two, that the evidence they intend to adduce, if they are given leave to reopen their case, will have a material effect on the case. And we are saying that there's no way that it will have a material effect on the case, given the evidence before the court. You know, even if they use her as a voter witness, you know. Even if they choose to use her as a hostile witness, my lords. My lords, we also wish to refer your lordships to the oft-quoted case of Dombo and others versus NAR, 1970 CC 68, a Court of Appeal case. And then,
fresh evidence on appeal.
Yes.
Yes, and it is not an appeal. So the principles are never the same. Adduction of fresh evidence on appeal has nothing to do with reopening of a substantive case at the trial court. Yes, to reopen and
my lord,
please.
My lord, the principles apply in pari materia. That is my submission.
Not only.
And the principles apply in pari materia. You know. And my lords, 68, a Court of Appeal decision. And my lords, again, in Poku versus Poku, 2007, 2008, 1996, Supreme Court of Ghana Law Report, 1996, 996, sorry. Now, my lords, it's our case that the decision of the court in Poku and Poku, even though referred to adducing fresh evidence on appeal, are the same in the case where a party closes his case and applies to reopen his case to adduce further evidence. They apply pari materia. And in that case, would CJ observe as follows at page 1015. Consequently, the invariable rule, as I understand it, is that in an application to lead fresh evidence or new evidence, the first criteria which an applicant ought to establish is whether or not the evidence sought to be adduced was not in the possession of the applicant party or was not obtainable by the exercise of reasonable diligence or human ingenuity before the impugned decision was rendered. It is only when this first hurdle has been surmounted that the court should proceed to determine the other pertinent question of whether or not the intended evidence would have a positive effect on the outcome. Stated differently, if the first criterion is not met, no useful purpose will be served by examining the other factors. And my lords, it is our submission in respect, if I may make submissions on the question of subpoena, or it is not a matter before your lordship. My lords, it is our submission that the application of the 65 Rule 4 of the High Court rules, CI 47, states, or that's 35 Rule 4. Yes, Rule 4. States thus, a writ of subpoena ad testificandum, or a writ of subpoena duces tecum, to compel the attendance of a witness for the purpose of proceeding in chambers may be issued out of the registry if the party who desires the attendance of the witness produces a note from the judge or register authorizing the issue of the writ. Further, Section 88(1) of the Evidence Act 1975, NRCD 323, provides inter alia that, except as otherwise provided in this part of, of Evidence Act 1975, states inter alia thus, except as otherwise provided in this part or in any other enactment, no person has a privilege to refuse when duly subpoenaed to be a witness. Now, my lords, the petitioner applied to this court to open his case and to issue a subpoena to compel the chairperson of first respondent to testify. My lords, this should be viewed, this application should be viewed in the peculiar circumstances that first respondent has already elected not to adduce any evidence in this petition. And the court has affirmed its right not to to adduce any evidence. My lords, the process of cross-examination involves adducing evidence. And so, my lords, it's our submission that the object of this application to reopen the case is precisely the object of their opposition to the respondents' election not to adduce evidence. And it is our respectful submission that the court, having upheld that right of the first respondent and the respondents generally to elect not to adduce evidence, cannot with one hand affirm that right and with the other hand disaffirm it by allowing the petitioner to subpoena him, to cross-examine him, and thereby adduce evidence from her. I think that would be inconsistent with the court's own ruling. My lords,
Mr. Abutuampa, based on the submissions you've just made, what would be your comment on paragraph 15 of petitioner's affidavit in support?
Yes, paragraph 15, my lord. Yes, my lord, it's saying that it has become necessary. My lord, we say that they have demonstrated absolutely no necessity. My lord, the petitioner has demonstrated no necessity. Because, with all due respect, they have not shown how the grant of the application would have a material effect. That's the necessity. Material effect on the outcome of the matter in dispute. They have not shown it. All that they have said is that the EC has a constitutional role. It has to be accountable. The chair of the EC has to be accountable to the people, so on. And your lordship, in their ruling, said that the rules that apply to ordinary people in these circumstances equally apply to the EC chair. That's what your lordship's ruling a few days ago stated. So, my lords, we do not see that they have demonstrated any necessity. All the necessity is based on the fact, the allegation that the chair of the first respondent is stopped from saying that he will not enter the box because she had already committed herself so to do, when the chair of the second respondent never ever committed herself to that and cannot thereby be stopped. My lords, we would with respect end with we will end with two other cases. My Lord, the first is the Northern Ireland case of Ryan Andrew Fulton, Ernest Fulton, and Cyril Fulton. Sorry, Ryan, R-Y-A-N, Andrew, and Fulton, F-U-L-T-O-N, Ernest Fulton, and Cyril Fulton versus AIB Group UK PLC 2017 NICA 42 or 2017 WL 03382220.
WLR or WM?
No, that's WL. L, that's all. Zero. At page 5.
He said 0, the citation.
The citation is, the first one is NICA 44.
Oh, okay.
Yes, 44. My Lords, this was a case where in the court below, the High Court judge refused an application for discovery because it did not satisfy the two important tests of disclosure, which are necessity and relevance. And my Lords, in your ruling on discovery, you upheld these two cardinal principles, necessity and relevance. My Lord, the applicant's appeal was accompanied in the case by an application for subpoena against various people, including counsel for the respondents, to produce discoverable documents. The court, per Gillian LJ, dismissed the appeal and disallowed the subpoena application, stating emphatically in its judgment thus: suffice to say that we are satisfied that the application in front of McBride J for discovery was correctly decided by her, and we affirm her decision. And this, my Lords, is the important statement of the law. Accordingly, we also come to the conclusion that there is no basis for the subpoenas now being sought, as they arise out of the claim for disclosure. If discovery is not appropriate, then subpoenas are not appropriate. My Lord,
Mr. Akoto, what's the relevance of this case to the present application?
The relevance,
you are now dealing with subpoena and discovery.
My Lord,
we've gone past that. We are now dealing with an application invoking our inherent jurisdiction to reopen the case.
Yes. But the reopening, my Lords, relate to the substantive issue of the matters they sought to elicit.
As at length on the reopening, but my brother is just asking you how that case bears any affinity.
No, because my Lord, there's a principle that a request for subpoena cannot be used to disguise an application for discovery. That's the principle of law.
No, come again.
A request for subpoena cannot be used to disguise an application for discovery of document.
No, but we've gone beyond discovery, and these are earlier interlocutory applications which we disposed of several weeks back.
Our understanding of this process in the circumstances of this trial is that they are seeking by their subpoena to elicit the very information that they failed to elicit in the application for discovery. And I'm saying that the principle is that what you cannot get by discovery, you cannot use a subpoena to get. That is the point, my Lord. And my Lord,
according to you, or according to them, their submission, you give them the promise that you don't need the discoveries. You don't need the discoveries because you'll be available to testify, and they can ask those questions when you are in a witness box.
My Lord, with all due respect, we never made any promise. We just stated the position of the law that a matter that you may not obtain through discovery, you may elicit through cross-examination. That is all. I'm not saying that we have promised to enter the box, because the time had not arisen for us to adduce
Mr. Okampa, you did not make that promise. Yes, we on record, it is there. But yes, because
my Lord,
and more so, you are not appearing for the first.
Yes, my Lord. Yes, that is true. Yeah. But
is it free legal advice?
No, my Lord.
Are you going to be paid?
I'm a party to this case, and as counsel, I have a duty to this court to draw its attention to the correct position of the law. Yes. So it doesn't. I think that it doesn't matter too much that I am not counsel for first respondent. Yes. So, my Lord, the last case, my Lords, I wish to refer your Lordships back again to the instructive words of Wood C.J. in Poku and Poku at page 998. The learned Chief Justice then admonished with great emphasis that, quote, an application to adduce fresh evidence is clearly circumscribed and only operates within its statutory limits. This rule is therefore intended to assist an applicant who has made a genuine attempt to look for evidence and has met with failure. Courts ought therefore to be adept at unmasking attempts by dissatisfied party coming through the back door and under the cloak of having come by new or fresh evidence, seek to fill in the gaps or lapses in his or her case. For the rule is not meant to aid the slothful or the indolent, the careless, negligent, or reckless litigant, whether acting pro se or through counsel. The application is not granted on compassionate grounds. Why is it that the EC, God, and so on should not go into the box? Those are not the grounds. Neither is it meant to give slovenly, particularly a litigant acting through counsel and who fails at the trial to marshal his facts carefully and fails to conduct his case properly by presenting essential evidence at the trial or through the necessary cross-examination, or also fails to conduct the necessary investigation which would have thrown light on the strengthen his case, a second chance at rebuilding his or her case. Under such circumstances, an unsuccessful attempt to lead fresh evidence cannot be met with the criticism that the court was visiting the iniquities of counsel on the client. Either for the law has made provision for redress where the loss of a suit is the direct result of recklessness or negligence of counsel. I mean, it closes. A party who goes to court has the sole burden, and let me emphasize, the sole burden of leading sufficient evidence to prove his case. He cannot rely on the weaknesses of his opponent or rely on his opponent in prosecuting his case. And it is for this reason that Sarkodie Iberima Jamfi and another versus Beidou, 1963, 2 Ghana Law Reports, 596. The Supreme Court, Coram Sarkodie Ado, Olenu, and Blade JJSC, speaking through Olenu JSC, Ozel, at page 597 as follows. The plaintiff could not have called any of the other eyewitnesses because they were the very people against whom he was litigating his title. And it would be nothing but madness for a party to rely on his opponents to prove his case. My lords, we rest our case.
Mr. Akutompa, I think you have to change your wig. It has lost its identity as a wig.
My lord, it gives it unique identity.
My lords, may I, with your leave, just make one short point in response as a matter of law. And my lords, I just wish to point out that we could not, at the time we closed our case, as a matter of law, we could not have subpoenaed Mrs. Jean Mensah because she had a witness statement that she had filed in this court on behalf of the first defendant, the first respondent. That witness statement was in this court in addition to the affidavit that I referred to. So at that point in time, we could not have subpoenaed her.
Mr. Chikata, just one. Flowing from the submission from counsel, in these proceedings, this court has upheld the right of the chairperson or the first respondent not to testify.
No, my lord.
No, by our ruling, let me land. We have confirmed her right to decide not to testify.
So a party.
Respectfully, the last but one page.
I'm sorry.
The last, I don't know whether you have a copy of the ruling. It is annexed to the affidavit of the second respondent. Yes. Unfortunately, they did not indicate the page, but it appears the last but one page.
The affidavit of the second respondent.
No, the ruling is annexed.
Yes.
It's annexed to the. Yeah. Mm-hmm.
Yes.
Yeah. I think the last paragraph, beginning with, the law is therefore settled that a party will not be compelled to enter the witness box and testify in support of a case.
A party? The chairperson is not a party.
Parties who decline to give evidence take, knowing perfectly well that the court will be left with no option but to proceed with the available evidence before it. Counsel for the petitioner has strongly submitted to us that we should not apply the Society of Lawyers case to the peculiar facts of this petition because the first respondent, being a constitutional body with defined responsibilities, must be brought before this court to be cross-examined as a way of accounting to the people of this country for its stewardship. The Society of Laws case, like this petition, also deals with witnesses who had served witness statements and have decided not to give evidence to be cross-examined. Indeed, the witness statement was served by Mrs. Jean Mensah.
Yes, but my lords, a party, your lordship just read a ruling in which your lordship referred to a party. The party in this case is the first respondent, not Mrs. Jean Mensah.
Yeah,
and we are saying,
under the circumstances, how do we declare the results from the Electoral Commission?
my lords, that is a perfectly legitimate legal separation. The EC is a corporate body, and the returning officer is an individual who happens to be the chairperson of that corporate body. You cannot, with respect, you cannot make the two identical. My lords, otherwise, why would the Constitution make the returning officer the chairperson, not the whole EC? The Constitution is quite clear in separating the role of...
We appreciate that, but then it is the commissioner who declares the result.
The chairperson, in her distinct capacity as chairperson, not the EC. So, my lord, I was just responding to the point about, lack of due diligence and so on and so forth, and I was just pointing out that at the point in time when we closed our case, there was a witness statement. That witness statement, yes, that's all I wish to add.
By court, this petition is hereby adjourned to tomorrow. That is Tuesday, the 16th of February, 2021, at 10 o'clock. Please, it's 10 o'clock a.m.
My lords, with all due respect, I have a little prayer to make. My lords, this court directed us last week that we should all file our written closing arguments.
The order stands.
If your lordship will hear me out, if you, by Wednesday, simultaneously, my lords, we have seen a situation where the court has ordered parties to file their witness statements by a certain date, and others applied for review and used it not to file, with the effect that we filed our witness statements before they filed. My lords, I just want to pray for an order to the registrar that if we file our witness statement on Wednesday and the other party has not filed
closing
addresses, and the other party has not filed because of maybe a review, they should not have any sight of our closing address. Yes. My Lord, that's our prayer. I think it's important to give integrity to the order of the court that all parties must file on Wednesday simultaneously.
As your lordships have indicated, this is a court of record. If he wishes to make an application in respect of the order,
Mr. Chikata, is it by implication that you are not going to file your closing address?
My Lord, this is a court of record, so we'll stick to our record.
All right.
The proceeding today has come to an end. It was an application before the courts seeking to reopen a closed case. As you know, they say litigation must come to an end at some point. Last week, the petitioner's lawyer, Mr. Chachi Chikata, closed his case. But today, Mr. Chikata has been making arguments seeking to reopen the petitioner's case. He's not necessarily coming under a court rule, but the inherent jurisdiction of the Supreme Court to grant this leave. The circumstances that have occasioned this application, he points us to paragraph 4 and 5 in that application. We'll get to that in a bit, but Mr. Chikata has also emphasized that in the chairperson's affidavit, she gave the impression that she intended to take the witness box, thereby establishing a concluded presumption which could not justify leave to adduce evidence. And it was this reasonable expectation that led to the petitioner closing his case. There was some bit of clarity, which Mr. Chikata essentially says, if the case is open, then the chairperson of the Electoral Commission will now be a witness of the petitioner. If application is granted, they intend to treat Jean Mensah as a hostile witness. There was argument against this application, as expected, by the lead lawyer for the Electoral Commission, Mr. Justin Namenuvo, who says what the petitioner is asking for is not warranted by any rule or procedure. Also says this current application by the petitioner amounts to abuse of the court processes. Supporting that closely is the second respondent's lead lawyer, Akoto Ampao. He says that such applications must be on two crucial grounds, which is that one, evidence was not available at the time the petitioner closed his case. And then two, if they reopen it, will have a material effect on the case. And there's no way that the court should allow that to happen. So the court says it is settled practice that a case can be reopened under certain circumstances. We heard Justice Tokodu there say that they can only exercise this discretion on extremely appropriate grounds. There were some lighter notes to today's session, as always. Mr. Chikata says it will honor the God Jean Mensah serves if she took the witness box. Mr. Menuvo unfortunately couldn't quite complete his statement. He started off by saying, God is a God of conscience. I'm not sure how that would have ended. But Akoto Ampao's wig, we were told by the Chief Justice, that it has lost its identity. He's got to change it. So basically, this is how I would like to sum up. We can bring up those two paragraphs, the basis for this application, but we want to say that the election petition update is brought to you in association with Petrus or clean fuel in full quantity. It's always a delightful experience. DBS Roofing, we truly are your roof experts. Kwa Mixture, the immune booster for your general well-being. My name is Mama Vio Swabwaji here with Koji Yangsing, who's been taking loads of notes. Joseph Akable is our court correspondent. He joins us. Joseph, we didn't think we'll get to midday today, but applications, as we've seen in this ongoing election petition, is not always so simple. What can you share with us after today's sitting?
And so it's been a day of interesting legal arguments that have been advanced by the various sides. And there was a bit of an interesting engagement at the very latter part of the proceedings, where you heard Mr. Akoto Ampao making a request of the court in relation to its orders that had to be complied by the 18th, 17th, to enable the hearing that is scheduled for the 18th. It had to do with the filing of the closing addresses, and he was saying that and they hold a view that in the event any party to the case decides for some reason to file some form of a review, they should not be permitted by the registry to see their documents which they will be filing as their closing addresses, as it happened in the case of the witness statements, where you recall Mr. Mohammed's side did not file their witness statement because they said they had filed for a review of the court's interrogatory ruling. And subsequently, when they were ordered to file it and comply with the court order, Mr. Ampao says they had access to their statement and they proceeded to file it. But that is by way of just the last issue that was dealt with. Essentially, the various types in this particular matter have in the last few hours, starting from 9:30 a.m., the advancing arguments in support of the request for the case of the petitioner to be reopened or against a reopening of the case. Mr. Chikata, who leads Mr. Mahama, has canvassed his argument. He insists that the court should exercise its inherent jurisdiction, its own powers, its own discretion to enable them reopen the case because there are matters that have come up in the course of the proceedings related to both pardon issues about an instruction purportedly given by the Electoral Commission chairperson in his own words to some of his witnesses, two of them actually, to go over and confer with the party's presidential candidates, which eventually saw a declaration of the results in their absence. And so those are matters that are important, and one person can account to it, and one person can settle those facts. And so it's important that the EC chairperson be allowed to reopen their case for a subpoena to be issued for the EC chairperson to come in and testify. We have heard the lawyers on the other side, Mr. Menubo and Mr. Kutampa for President Akufo-Addo, make the point that it is very difficult to marry this particular application with the court's earlier decision that a witness cannot be compelled to give evidence, being that this witness that the court was speaking to, one of them was Mrs. Jane Mensah. And so should the court decide otherwise in this instance, we enable them to reopen the case and a subpoena to be issued, it will have to mean that the court has repeated its own earlier decision on that particular matter. And so those are briefly the major highlights of the arguments that have come up so far. And even at the latter part of the proceedings, you heard the justice of the court, Mafusau, engaging Mr. Skata on this particular point about the court's earlier decision and what should happen. The court has taken a break. It's coming back tomorrow at 10 a.m. to deliver its ruling on this very important issue that has the potential to now either pave way for the court to come to a conclusion on this election petition, or perhaps reopen it up and allow for further directives that would see some few days of hearing take place yet again.
And Joseph, the bit about Justice Mafusau's engagement with Mr. Chikata on this matter, Mr. Chikata sought to make a fine distinction between the Electoral Commission's witness and the Electoral Commission chairperson who was the returning officer in the 2020 presidential elections, that the petitioner is hoping that if this case is reopened, they can get her to be in the witness box. Explain again what the issues are with regards to this matter, because these are they two distinct matters? What exactly did the court say?
Mr. Chikata's argument was to the effect that when they closed their case, the first respondent was called upon to lead evidence, and the first respondent elected not to lead evidence. And the first respondent in this instance, he said, refers to the institution of the Electoral Commission. He says in this particular instance, when they are seeking to have the case reopened, is to subpoena the chairperson of the Electoral Commission, who is an individual separate from the institution of the Electoral Commission, which is a respondent in this particular case. And in which instance, the court has said that that party to the case can elect not to lead evidence. And so his point is that Jane Mensah, as the chairperson of the Electoral Commission, is distinct from the Electoral Commission as an institution that has been sued, in that as chairperson of the Electoral Commission, he was the returning officer for the presidential elections. And so it is under that directive that they are coming under. So he was urging the court to take the view that it's not the case that whatever decision it decides to take will mean that it is inadvertently defeating its own earlier decision. In that earlier decision, the court was talking about the fact that it cannot compel the first respondent to lead evidence. In this particular instance, they are seeking to bring in an official who works at the first respondent, who in this particular case was the returning officer for the presidential election. And so that was the distinction that Mr. Chikata sought to make with regards to the issues relating to Jane Mensah and the Electoral Commission as an institution.
Joseph Akable will return to you when the two parties start addressing the media. We'll take a breather. When we come back, Kojang Singh will share his notes with us.
Yamwa kwa baba kase boyso. E fra me vim lady e fia pokua. And na ibiase aye hu. Esan say yare adoso enketewa ne akese. And am so me ebusa nkofo say apomodin ma papa. Anything.
Apomodin ni say obebo adwuma akwa ba onti brebia.
Ahonde mrosro. So be sipi sita. Ana. Se obeye bo heavy. Debia.
Oyiwa obia fa hoden. Obia penkwa. Edroni ni Hepa Plus mixture we na onomo a enkwamwa na nya ahode akweti anyare wo bia ebeba oni pedua nim Hepa Plus mixture ema pomode mapa
Hepa Plus mixture ebo ma ni pedua ni gina yie pa Hepa Plus mixture enye mankwa na wondi fie dumienu apemfo ana batai FD ahwehwe sagade krato emu ajatum se eye
Hepa Plus mixture ema pomode mapa.
It's time to go digital. Create your unique online store in a few clicks. Connect your Facebook shop, Instagram, or WhatsApp business and add your products, prices, images, and stock levels. Collect payment online, offline, and in your shop. Get instant notifications of your orders and payments and deliver your product to your customer's doorstep with our delivery service. Manage your sales, customers, and staff from anywhere at any time. Get our Digipack and up to 200,000 CDs working capital to grow your business. Visit digistoreafrica.com and set up your business for free. Digistore, powered by IP and EcoBank.
Any mama do fi. Oye dwuma odukasi. Anopa biara me nua ba sori ahoɔden mu na ɔkwadwuma. On complaining da. Sɛ ho ba bitutu no. Sanso na me bra o efitani. O to engine. No opagya engine. Be ka adwuma sɛ de sitie. Da bi biara no. Ho dendenden. Me ameyire. O store no adi ni dwa. Me yire ensori anopa enka sɛ na nia ha anase ne ho ye ne mreda. Sanam papa ne mfia konkan. Ɔno nso complaining da. Sɛ de ho ba bi ye ne ya. Ɔsori anopa na no afanse kan. No ɔkonefu. Me akrobeto. Madwuma meyɛ. Me kan news na me na me kɔbɛba ta biara no ɛbere me de bedampo na adias nanso men sorry da krokran ka sɛ me hu ba bi ya me ya ne nyina gyina sɛ yo secret ahuntasɛm ɛyɛ duru a ɛde boy ho ba ne nyina ni kowa mesha kurani ɛyɛ duru a wonom a ɛbo ni padua no ɛma wo si pi wo sita na yare da hɔ ɛya nunum bi na obedi adanse wo benya bi atɔ o ba bi eton no bia na opedodo otu nsu a frɛ sɛ telephone number si kowa mesha abusua ahuntasɛm
Yama apemfo nkoda a woni mfie dumienu ne mma ɔma nkwada no fo FDA ahwehwɛ ejade inkrato yi agya tum sɛ ɛyɛ
man. And then if you are getting watch me with Januma, you know very well said the market is booming.
Meaning I'm engine BMO. Oh, Nipen here more.
Engine BM.
Boss, what's wrong with the engine?
He's not using the proper engine oil.
Very selling, fair fit.
Which you are? Makaza untie. See, I've said this several times. You don't listen to me. Huh? What are you trying to say, Ameba? Why? Anyway, wait, J. This is the real deal. Engine oil, papa. Ever since me start to use petrol solid lubricants, my engine no more doubt is so crabby soon. Sir, I don't have any problems.
Osman, rim starting at tears.
Petrosol.
Petrosol Platinum Engine Oil. Quick and thick.
We pass the tape and declaring plastic and what? And then with them, the idea seal. Factor. As I can introduce DBS Lifestyle Gauge Trusses amount. The same thing, baby, I say, Yama minimum the day. And you know the good dance. And the crow, not sending me a benina and your papa. So DBS Lifestyle Gauge Trusses. Yet the computer not generated. Into and I didn't go straight. And if it's a not guilty, then want to mean the Henry. A good answer, I feel finito. More musicians saw that. More music factories, and as a dark as Biano, me recommend DBS Trust Samamo. DBS Trust finito.
and you're on your most credible news source. This is JoyNews, our election petition update in association with Petrosol Clean Fuel in full quantities. Always a delightful experience. DBS Roofing, we truly are your roof experts. Go and make sure the immune booster for your general well-being. Kojang saying, we're told both parties are on standby to address the media, except that they don't know which party would go first.
Well. The same confusion, different day. Yeah, but we have been following proceedings with rapt attention. And it's very interesting. Today, I noted specific points all the way through. The points may not be connected to each other, but each one seems significant on its own. For example, lawyer Chachuchi Kata made this point in his argument. He argued that, look, the respondent made an argument against the motion for interrogatories by saying that, the petitioner, the petitioner's rights are not affected. We'll come back to this, I think.
Absolutely. Let's join Kojo Pankrama now.
That application. I will come to the specifics of the argument and what we've been arguing and what we look forward to tomorrow. But let's go back. Why are we here? The petitioner has told the Supreme Court of the Republic of Ghana that, among other things, nobody won this election, and therefore there should be a rerun. And has notified the court that he has 5 witnesses who will prove this. The court gave orders that all parties should file witness statements and indicate to the court. A witness statement is an indication to the court the summary of the evidence in chief. Indicate to the court how many of these you want to put in or you intend to rely on. If you read CI 47 and CI 87, you intend to rely on. That's the expression. Now, you'll recall that the first and second respondents complied, and the petitioner did not comply initially. And the petitioner then came for leave after we had filed our witness statements to file his witness statement. Be that as it may, the many attempts to put impediments in the way of the full trial gradually were removed by the court, and we got to the full trial. The petitioner initially called 2 witnesses who were expecting will come and make their case. And for all of those who have followed the trial so far, it begs the question, or it remains at large, whether or not the initial 2 witnesses were able to make the case for the petitioner. The petitioner then sought leave to bring in a 3rd witness, Ms. Rojo Metil-Nunu, who then brought in a witness statement and then came to testify. And then at the end of Mr. Rojo Metil-Nunu's testimony, without any compulsion from any quarters, the petitioner announced to the court that he had closed his case. He was done. He had finished making available to the court all the evidence necessary for the court to find in his favor. The first and second respondents, when given the opportunity, then announced that they were also closing their case. They did not think that the petitioner had raised any reasonable cause that required them to bring in witnesses to come and testify, despite the fact that they had initially suggested to the court that if it became necessary, these were the witnesses they intended to rely on. It is at this point that the petitioner has brought a new application to the court, after the court has made orders that we should file our written addresses, I think by Thursday, by Wednesday towards final judgment. Now, the petitioner is asking the court to give it permission, because it's not a right, to give it permission to go back and reopen the case and adduce some new or some fresh evidence. It begins to beg the question, why would somebody who has told the court that I have closed my case, I've made my case, I've brought all the evidence and the witnesses that I believe can make my case, who earlier argued that this was an ironclad case, this was solid on all fronts, why is the petitioner now asking for permission to go and open the case to adduce new evidence? When you ask, the argument they make is that because the Electoral Commission, through its chair, advertised to them, indeed the word they used earlier today was promised, that they also get in the box. Well, as has been explained by our counsel and indeed the bench through its previous rulings, the response to the court order to file a witness statement and even the affidavit on interrogatories do not constitute a promise to get in the witness box. And in any case, if you have an opportunity to cross-examine You cross-examine when somebody has led evidence in chief. So if the respondents have not gotten into the box to provide evidence in chief, what is this cross-examination going to be on? The court has already ruled that a party cannot be compelled to adduce evidence. Today, you have seen our colleagues come with an application asking for a subpoena. What's a subpoena? To compel the EC chair to get into the box. So the very thing the court said the last time we were here, they've come with an application with a different name or a different instrument asking the court so to do. You also heard learned counsel on the side of the first respondent and second respondent raise a number of reasons for which the position of the law does not support the argument that they are making. And I hope you took notice of the fact that for several minutes, the Venerable Akoto Ampah on his feet was citing various authorities in times past that do not allow the party, that is a petitioner, to do what he's seeking to do. I want to end by reiterating two of those authorities. One, Poku versus Poku, the former Chief Justice Georgina Wood. And I just read to you, an application to adduce fresh evidence. And why we are saying this is fresh evidence is because when you come and ask to reopen your case, why are you reopening your case? You want to reopen your case because there may have been something that was unavailable to you, which you are making now available to the court. And that is why we're asking the court to apply the rules of adducing fresh evidence in this instance. If not, then you are saying that you want to lead further evidence on something that you've had an opportunity and you've led evidence on already. And you are now probably thinking you didn't do good enough of a job, and that's why you want it reopened. But the later Chief Justice, as she then was, said an application to adduce fresh evidence is clearly circumscribed and only operates within its statutory limits. The rule is therefore intended to assist an applicant who has made a genuine attempt to look for the evidence and has met with failure. Courts ought therefore to be adept at unmasking attempts by a dissatisfied party coming through the back door and under the cloak of having come by some new or fresh evidence, seeking to fill in the gaps or lapses in their case. For the rule is meant to aid the slothful. The rule is not meant, I beg your pardon, for the rule is not meant to aid the slothful or the indolent, the careless, the negligent, or the reckless litigant, whether acting pro se or through counsel. So whether it's Mr. Mahama or his lawyers who have been indolent or careless, negligent, reckless, the rule does not support them. The very final quotation that I want to reiterate, as articulated before the court by the Venerable Akoto Ampah, was in the case of Berma Jemfi and another versus Bedu. The Supreme Court, Koramsa Kodiado Olenu and Blay, justices of the Supreme Court, speaking through Olenu, observed at page 597 that, and here's a quote, the plaintiff could not have called any of the other eyewitnesses because they were the very people against whom she was litigating her title. And please listen to this part. The Supreme Court says, it will be nothing but madness for a party to a suit to rely on his opponent to prove his case. The Supreme Court of the Republic of Ghana says it will be nothing but madness for a party to a suit to rely on his opponent to prove his case. You heard counsel on our side lay all of these authorities before the Supreme Court, and we look forward to their ruling tomorrow. As to whether or not you heard the compelling legal argument with authorities backing it from the other side, I'm sure tomorrow when the justices came, they will tell us, or when the justices come tomorrow, they will tell us which of these arguments and which of these authorities have met their pleasure. Those will be our comments. If there are questions, we're happy to take them now. Yes, sir.
And the lead counsel for the petitioner asked for interrogatives. He argued in court today that your lead counsel argued then that you said that the petitioner will suffer no injury to his application if the interrogatives are not granted. Then comes the time when he's supposed to cross-examine the second respondent or the first respondent petitioner or the witness, you turn around and say that he cannot do that. And he says that they came to court with a belief that they were going to cross-examine the first respondent.
So let me quickly respond to that. There were 2 points that were made. One was that the petitioner will suffer no injuries if those interrogatories are not granted. Why? Because all the material issues, including documentation that they need for this trial, is already available to them. 2, the questions that they are seeking to ask must be of relevance to the issues at stake. And even if they do not get an opportunity to ask relevant questions, i.e., questions that between the pleadings and the answer are left hanging, that the court will require some testimony before it comes to a determination on, if there's an opportunity for cross-examination, you can put those questions forward. Cross-examination comes after you have supplied what we call evidence in chief. Now, it is expected that you would discharge the burden of proof on you, so that I feel that if I don't get in the box to lead evidence in chief, I am at peril. And then you have room to cross-examine me. So it cannot be that you then fail to meet those standards and seek to come through the back door, that you should be given an opportunity to compel the witness into the box, who has not led evidence in chief, by the way, to be cross-examined because you have not been able to establish your case in the first place. Now, this second argument of they relying even on this argument in the affidavit, it cannot be true, because you notice that they applied for a review. If they had taken it on face value, that okay, therefore, we are resting and we'll go on a cross-examination when the opportunity comes up, they will probably not have gone for a review. But you notice that they sought to go back. In fact, they did. They went back to the court to say they disagree with it, and the court ruled them out. How can you turn around today and seek to reprobate that which you sought to approbate, or approbate that which you sought to reprobate? You cannot do that. If you have taken a position that you are coming to court to make an argument before the court, gather your evidence and come and do same. If you have completed that and you have announced voluntarily to the court that you have closed your case, why are you today now showing everybody that indeed you yourself are recognizing that you did not make a case compelling enough? And that is why you are saying that until and unless the EC chair is compelled to get into the box, you are not able to complete your case. And this is the hurdle that they have to cross. We look forward to what the court will say tomorrow.
Yes, counsel for the petitioner, in trying to counter the argument put forward by the other side, first respondent, indicated that he's saying that she's not capable, will not be capable to mount the box. And so he quoted, Mr. Chikata, quoted Evidence Act Section 53 and 54, to incited some cases, the rules, that it might be someone, even a little child can be allowed to go into the box, and so on and so forth. What is your response?
So let me just put that in perspective. He didn't quote cases. We made an argument in our affidavit that, no, in fact, it was the first respondent who made an argument in her affidavit that she is disqualified from being a witness. Why is she disqualified? She is a party to the case. If you want to subpoena a witness, the practice has been that this is usually a third party who has information that can help your case. Here is a case in which you have brought a party to court, and you were hoping that that party will get into the box and give evidence to help your case. And the party has outsmarted you, has taken a superior legal tactic, and has said that I will not get into the box. If this is all that you have to tell the court, let the court judge based on this. Now, the party says, I am disqualified from also being a witness because I am a party to this transaction and I've elected not to get into the box. And so the court cannot compel me. What Mr. Chikata did was then to go under the Evidence Act of who is disqualified from being a witness. Yes, there's the general rule that anybody who has information that is relevant can be a witness, and the persons who are disqualified are A and B and C. But why that does not apply in this case, respectfully in our view, is because the EC chair is a representative of the EC. The EC chair and the EC, and you heard the bench say that for the purposes of this case, you can't even separate the two. So a party, and that's why she makes the point that as a party, she's disqualified from being compelled by somebody as a witness on their behalf. And it is interesting that now the supposition from Mr. Mohammed's legal team is that when they mention 5 witnesses, because now that's what they are saying, that when they mentioned 5 witnesses, they intended to call the EC chair as one of their witnesses. Why are there 5? The other 2 who are going to make their case for them, where are they? Because now what they are suggesting is that until the EC chair gets into the box, they are not able to make their case. We'll hear what the court says tomorrow. Yes, sir.
So I noticed 2 main things in court today. One had to do with the application for reopening of their case, but the second also had to do with a mention of the fact that Mr. McMenu had said something which was recorded on tape, which is something that the lead counsel for the petitioner would like to play in court. Throughout the arguments of the second respondent's counsel, no reference, at least to the best of my knowledge, was made to whether or not the tape should be played. However, the second respondent's counsel appeared to be defending the first respondent and not the matters that directly had to do with the second respondent. That left me a bit amazed.
Let me quickly respond to that. In the 2013 Supreme Court election petition, the court even allowed friends of the court, amicus curiae, to come into the court and to supply a brief on legal matters to aid the court in arriving at a position. Lawyers, sometimes when you are in court and a matter is being disposed of in court and there's a point of law or a matter that you think you should bring to the attention of the court, even if you are not a party or counsel for any of the parties, you can pray the leave of the court to provide some legal support to the court as a friend of the court, amicus curiae. That was in 2013. Subsequent to 2013, the government of the day took a CI 99 to Parliament under the leadership of Marietta Breopon, Attorney General at the time, had it passed to limit or to constrain the framework of presidential election petitions. So now, you notice that even the petitioners, only one person can petition. And arguments from friends of the court are not necessarily being entertained. But the second respondent is a party to this case that is before the court, and therefore has the right and opportunity to address the court on matters of law. Even if he's of the view that some matters of law have been missed by the petitioner or the first respondent, he's well within his rights to assist the court with legal arguments on that. And so if he rises, and that's why he said with respect to the court that it's of no consequence if his argument appears to favor the first respondent. It's of no consequence, because once he is a party, and once the matters that are being discussed will affect his client, he is well grounded to advance arguments before the court. In 2013, even persons who were not parties or counsel for parties could do so. So I think that explains it. Now, the first argument of the tape, I'm sure you were all in court when Mr. Rojo Metununu mounted the box. I suspect you observed that the tape was played, was it not? The tape of Peter McMenu's interview with, what's his name, Paul Adumoche, was it not played? How does playing that tape 2 times change the results of who got 47 and 51? It's been played already, not so? So what is the basis on which they are requesting for the same tape to be played again? There was no reason for us to spend time speaking English around that particular issue. It is matters of law that our counsel sought to address before the courts, and that's why they dealt with it. But that tape, if you recall, has been played already. Playing it 2 times will not change the probative value. Yes, sir.
Yeah, so just before the court rose today, counsel for the second respondent sought to draw the court's attention to make an order sort of compelling all parties to file by Wednesday. What were the concerns he was seeking to raise?
Let me quickly clarify. He was praying the court to make an order that when we file our written addresses, they ought not to be cited by the petitioner. And that is assuming we don't all file simultaneously. They ought not to be cited, because we are beginning to believe that the petitioner is adopting a strategy of waiting to see what we file and then coming back to file theirs, which should be the other way around. The petitioner is the one who was supposed to have filed his witness statements first. Despite the clear court order, the petitioner's legal team did not do it. First respondent, second respondent filed ours, and then they had to ask for leave to do that. I think the written submissions on the submission of the preliminary legal objection, for example, you find out whether or not they filed and when they filed. And that is why we are making, or that is why our lawyers are making that prayer to the court, that we don't want a situation where we come and file our written addresses, and then they, because the registry operates as a court, to create the public record, they will get an opportunity to read it and then come and now find a way to come and respond to it. And that's why they are making that prayer, that for the integrity of the orders that the court is making, we all either file simultaneously, or if we don't, and they for some reason, because they have hinted that they may go for a review. That's the same instrument they used the last time, review, so we won't file. Then they read ours, then they come back. Because they've done it before, our lawyers are praying the court that if they adopt the same strategy this time round, the registrar should be instructed to ensure that they don't cite ours and use it as an opportunity to go and find some arguments to respond to what we have put in. We should all file ours simultaneously. Thank you very much.
A spokesperson for the second respondent in this case, Kojo Ponkroma, addressing the media. But Kojo, you were on to the interrogatories, I think?
I think so. Let's see how many of these separate points I can get through quickly. Mr. Chikata was making an argument, trying to justify why the case ought to be reopened. And his point was that a certain modicum of, let's call it justice, has been denied the petitioner. What was he talking about? He was talking about the application for interrogatories. When he made that application, one of the defenses mounted, or the arguments against it, mounted by the respondent, the first respondent, the Electoral Commission, was that denying that application will not deny the applicant or the petitioner of justice, because there will be an opportunity to cross-examine the witness. All right? So if, based on that, if after saying that you now decide not to give that opportunity to the applicant, the petitioner, to cross-examine the witness, then you are denying them the same justice that you said was guaranteed them, for which reason their application should be turned down. Now, I got that, but I wondered what it has to do with the court. I feel as if the court is a disinterested party in that exchange. You know, the court simply has to make a ruling on Mr. Chikata's, submissions. And I'm not a lawyer. Again, we're not lawyers. We're observing. We're observing. So I could be entirely wrong here. But it seemed to me as if Mr. Chikata was making an argument to the petitioner, when perhaps it should be an argument to the court, or an application to the court. But anyway, what do I know? It was a significant point, though. Okay. A significant point.
To the first respondents, I guess.
Yes.
That you wanted
yes.
to say.
Yeah. First respondent. Did I say second respondent?
No, you said to the petitioner.
Thank you. To the first respondent. I appreciate that. Justice Tokonu. I always get excited when I hear her voice. She often has very interesting points to make. And she made one today. So she reminded Mr. Chikata in the middle of a point he was making that she basically said, I'm paraphrasing, you are asking us to exercise our discretion to either grant or deny your application to reopen your case, and then subsequently your application to file for a subpoena. That discretion is to be exercised under extremely appropriate grounds.
I heard you emphasizing extremely.
I have never heard that expression before. I mean, something is either appropriate or inappropriate. But Justice Tokonu went to the length of describing appropriate as extremely appropriate. I think this takes us back to some points that we were observing last week. The fact that this court is a stickler for the rules. I mean, the Supreme Court has the power to create precedents. But it's up to them to decide whether they're going to create a precedent or not. And this particular panel, so far, with all of their rulings, they appear to have a very, very hefty respect for the rules. They are not always willing to tamper with them. They are not always willing to rewrite or reinvent the wheel. They feel that so far, in the cases that have, in the applications that have been put before them, the rules have been sufficient to clarify them. You know, so I wonder how they are going to deal with this pending application to reopen the case. Whether they will simply, as they've done in the past, rely on the rules, or whether they will look at the situation and find an interpretation that, in their view, serves the purposes of justice better than whatever is already existent in the rules. I can't wait to find out. Now, another point from Justice Tokonu, which was countered by Chachu Chikata. She said that the truth is at large. She was making reference to a particular argument that Mr. Chikata was making. But Mr. Chikata's response was that, well, actually, no. The truth is everything in this one. Because the first respondent's lawyer had taken many opportunities to question the truth of the testimony of the petitioner's witnesses, all of them. And he gave examples for each of them. But I found it interesting, the concept that, you know, and this is where I'm learning about the Supreme Court, that in some cases the Supreme Court can hold the view that the truth is parallel to the point. You know, and this is important for those of us who are observing, you know, because we may think that, oh, it's about, you know, finding out who's telling a lie and who's telling the truth and all that, but it's really just about the law. You know, it's about finding out how the law is to be applied in this case, how the Supreme Court considers the law to be applied in this case. That is all that matters. Sometimes the truth can be a byproduct. That is fascinating to me. Anyway, and then, of course, you made the point about in honor of the God that she serves, and that was going back and forth for quite a while. Now, Mr. Kotampao's arguments were also quite interesting. And he made this point that once a petitioner says, I have nothing to add, they are essential. I mean, those are the words. They have nothing to add. So he's calling on the court to take the petitioner at his word, you know, that he has nothing to add. So if you have nothing to add, then the court is obliged to conclude matters there. I wonder if the court will be of that view. You know, if someone says, I have nothing to add, and then suddenly goes, oh, I remembered something I'd like to add, should the court say, no, you said you have nothing to add, therefore it is over. The court has already established that there are precedents for a case being reopened, but they have also set the parameters for those precedents. Okay, and they have said that especially it is if there is new evidence. So Mr. Chikata, I don't know if in his argument he went to the point of new evidence. I don't know if he suggested that there is new evidence.
Okay, so I think the basis is you should not adduce new evidence.
Oh, you should not adduce new evidence.
Exactly.
Right.
It shouldn't be, yeah. But you know, as we go on reminding you of what has happened, what has played out in this court case today, we're also waiting for the petitioner's team to address the media. I'll bring that live to you right here on Joy News. You're done with the notes?
The final point, and I think this is another thing we started talking about last week. Mrs. Jean Mensah is not a party to this case. She is the witness to one of the parties to this case, the Electoral Commission. The Electoral Commission decided that Mrs. Jean Mensah will be their witness. When the Electoral Commission rested their case, the consequence of that was that their witnesses, whoever they may be, will no longer mount the stand. Mr. Chikata is now arguing that since you have rested your case, that person is not your witness anymore. The person can be my witness now under subpoena. And that is the case that he is making to the court. Let's see if they agree with him.
Absolutely. Okay, some learned persons, because we're not lawyers, say the court will be thinking about a few things and arriving at a decision. Will it help to answer any of the 5 questions put down by the court by way of the 5 issues raised that it intends addressing, and based on which it would make a determination at the end of this case? And I'm talking about the decision to reopen or not. And What new thing will the witness be bringing on board the case? It must not be fresh evidence, as they say. This election petition update is brought to you in association with Petrosol, clean fuel in full quantities, always a delightful experience. DBS Roofing, we truly are your roof experts. Koa Mixture, the immune booster for your general well-being. Case adjourned to tomorrow, 10 a.m. Court will be making a decision, but its previous directions, the orders that it has given, also hold. So by 17th, all the sides will have to submit their closing arguments. And then on the 18th, that's the schedule that's been given until we get further directions from the decision that the court will deliver tomorrow. All right, so that's the expectation, really. We're waiting for the other side, which is the petitioner's team, to also address the media. And then I guess we all have to wait for the court, the justices of the court, the 7-member panel sitting on this case, to make their decision. It's our election petition update. Please stay with us. We'll take it back to the Supreme Court now.
Yeah.
Okay. So I asked you, sir, who?
Okay. Good afternoon, ladies and gentlemen of the press. Today, before the Supreme Court, the lawyers for the petitioner brought a motion or an application to reopen his case on the grounds that were stated in the affidavit of the petitioner. And the basic ground was that at the time that the petitioner closed his case, the petitioner did so with a legitimate expectation that the petitioner would have the opportunity at the appropriate time to cross-examine the witnesses of the respondents. Now, ladies and gentlemen, you realize that the respondents filed witness statements. They also represented to the court that they were going to make themselves available for cross-examination. So at the point in time that the petitioner closed his case, he had that legitimate expectation that he would have the opportunity to cross-examine the chairperson of the Electoral Commission in particular. Now, let me put it right that certain misrepresentations have been made to you this afternoon. It is not true in law that a party cannot be asked to testify or a party cannot testify at the trial. That is not true. That's not a true legal position. In fact, you were all here in 2018. His Excellency the Vice President, Dr. Mahmoud Bawumia, testified during the election petition that was filed by himself, His Excellency Nana Addo Dankwa Akufo-Addo, and Jake Obi-Chebi Lamte. They were all parties. Bawumia was a party and he testified. So it is entirely wrong to say that a party cannot testify at the trial. In any case, the subpoena that we are seeking to bring or to file in court is not designed to make the Electoral Commission as a corporate entity to testify or file a witness statement and be cross-examined. It is directed at Madam Jane Adukwe Mensah, the chairperson of the commission and the returning officer under the Constitution for the 2020 general elections. Now, I must put it on record that as a returning officer, she is distinct and different from the commission as a corporate body. there's a long line of decided cases on this matter, dating back to the famous English case of Solomon and Solomon. So for them to seek to confuse Jane Mensah in her capacity as the returning officer with the Electoral Commission is, to say the least, disingenuous. And I think the lead counsel for the petitioner made that very, very clear to their lordships. And you realize that when their lordships were questioning, it was his lordship, the Chief Justice himself, who made a reference to their ruling. And in that ruling, it was that the justices took the position that you cannot compel a party to testify. And we are not seeking to compel a party to testify. We are seeking to compel Jane Mensah to testify in her capacity as the returning officer for the elections. Okay, and she said, as I've said, it's as if to say that the chairman of the board of directors or the CEO of a company is the same as the company. You can't conflate the two. So let us, make that abundantly clear. We also want to make it clear that we are not in court seeking to compel her to testify because we think that our case hasn't been made out. First of all, let me say this. It is not left to the lawyers of the respondents to determine whether on a balance of probabilities we have been able to make out a case. They have decided that given the evidence that we have laid, they will not put their clients on the stand. It is now left to the court to decide. And by the way, the mechanism of cross-examination is a time-tested tool for eliciting evidence. Now, going by the logic that has been espoused by Kojo Opon, or the Honorable Kojo Opon Nkrumah, it means that even in a normal trial, the plaintiff will give his evidence, the defendant will give his evidence, and no one will have a right to cross-examine. And the court can go ahead and then make a decision based upon that. I think that that approach is alien to the law. It is not known to our system of jurisprudence. Let me also make it clear that there is nowhere in CI 99 that it is provided that a party cannot seek to issue a subpoena to bring a witness to testify. Now that point was made by the Honorable Kojo Opon Nkrumah, and then he tried to link it to the fact that the Honorable Marietta Brew Opon Apia Opon, was the Attorney General at the time that CI 99 was formulated and laid before Parliament. Now, if you look at CI 99, it does not provide against compelling a witness to come and testify. So the subpoena that we are seeking to issue is in pursuit of the truth. We want Ghanaians to know how 51.589 became 50.08 something. Ghanaians, have a constitutional right to know. And so for you to say that just by reason only of the fact that we are seeking to get her to come and testify, we are doing so because a case is empty and there's no evidence to prove it, is totally disingenuous. And so for me, for us as a team, we have made a case, but we want the court to see that the truth in this matter has been revealed. And also, you remember that lead counsel, Mr. Tachuchi Kata, made a reference to something that Jane Mensah said during her declaration. In making the declaration on the 9th of December, she said, glory to God. Okay? That she was giving glory to God for the fair and transparent elections that have been held. Now, there is no better way to glorify God than to tell the truth. The truth is very, very important. If you want to glorify God, you take an oath and you tell the truth. And Christ himself said it. In the Gospel of John, chapter 8, verse 32, that you shall know the truth, and the truth will set you free. Jane Mensah should voluntarily take the box, tell the truth, and that truth shall set her free as the returning officer of these elections. May I have some questions?
Okay. Thank you very much, Dr. Ayine. The respondents have said umpteenth times that your side and your lead counsel did not show ample evidence to, as it were, ask for the reliefs he's asking for. I know as a spokesperson, you say that he has adduced enough evidence, and the key word here is material effect. That's the word they used here. Are you not worried?
I didn't get the last part. Can you come closer? Sorry.
Mm-hmm. Thank you very much again. My question is that counsel for the respondent have said umpteenth times that your side has not exhibited or shown material effect to the reliefs they are asking for. And I'm saying that I know as spokesperson for the petitioner, you say that he has shown enough evidence. But on a scale of 0 to 10, how sure are you that this new application you have tabled before the court would not suffer another setback?
Well, that is an excellent question with respect to the level of certainty that it won't suffer a setback. All right? Because if what has gone before is anything to go by, I am not very optimistic. But I am disappointed that the court may not give me a reason to be very optimistic. All right? However, when it comes to whether or not we have laid sufficient evidence, the fact is this. We laid evidence to show that there were infractions. And you witness the fact that we laid evidence showing that there has been vote padding. And they themselves admitted that there had been vote padding. We laid evidence showing, for instance, that in some cases, such as in the Eastern region, they brought documents that were conflicting. We also laid evidence that stands uncontradicted, that the Form 13 that they sought to tender is an afterthought, or was an afterthought. And I think that is where they are running away from. Okay? And I will wait for the court's ruling on this one to tell you why the Form 13 is the reason Jane Mensah is running away.
Thank you very much. In your address, you spoke about the fact that the court, in this ruling concerning the application for the last one that the court sat on, ruled that indeed the court cannot compel a party to give witness statements.
That is so.
What's your operationalization of the use of the word party? Because for us as lay people, party could also mean an individual interested in a matter. Really?
Well, are you done with your question?
I am done, yes.
All right. From a legal, technical point of view, Madame Jane Mensah is not a party to this suit. The two parties, besides the petitioner, are the Electoral Commission of Ghana, a duly constituted independent corporate body under the Constitution of the Republic of Ghana. And because it is a duly constituted independent body, it could have decided that Mr. Tete or Dr. Bosman should be the ones filing this in the witness statements. Now, if that were the case, wouldn't it have been proper for the petitioner to then say, look, the person who declared the results and the person appointed under the Constitution to do so is Madame Jane Mensah, and I want to subpoena her to come and give evidence in addition to what has been given by either Mr. Tete or his fellow the deputy commissioners. That would have been proper in law under the Constitution and laws of Ghana. That would have been proper. And so to say that because she is representing the commission, she is the commission, all right, it's a legally untenable proposition.
Thank you.
I have a question. All right, thank you very much. Please, what do you say to the argument by the counsel for first and second respondent that the court has already made a determination on the fact that it cannot compel the EC chair to mount the witness box? And so you coming through with this application to reopen case and then to subpoena her is an attempt to go through the back door and essentially asking the court to rescind a decision that it has already made.
Well, you know, I would have referred you to the answer that I gave to your colleague from the GBC. But let me explain again, okay, that the whole notion that is a judicial bar was introduced into the argument by one of the justices. And we confronted them with their own ruling. And in that ruling, constant reference was being made to the party, a party to the proceedings. And I have just said that Madam Jean Mensah is not a party to the proceedings. Now, the fact that she had elected to give evidence on behalf of the Electoral Commission itself, on behalf of, shows that she is not the Electoral Commission. All right? Logically, you cannot say, I am doing something on behalf of somebody, and then turn around and say, I am that person. I don't see how you can do that. So, for us, she's not a party to the proceedings, and therefore, all right, then if that were the case, then Rojo Metilnunu is the same as His Excellency John Dramani Mahama. Will you conflate the two? Thank you.
Thank you.
Let's submit.
You heard Dr. Dominic Ayeni speaking for the petition, addressing the press after today's court's proceedings. So the court will sit tomorrow to rule on Mr. Mahama's application to reopen his case. Mr. Chikata has disclosed that if the application is successful, he will subpoena the EC chairperson as the petitioner's witness. He says Jean Mensah will be treated as a hostile witness. What would the court decide? Well, join us at 10 a.m. tomorrow. We're grateful